my students. Today we shall discuss about meaning and nature of right. What does the term right denotes is within the scope of the study of jurisprudence, which aims to define as to what is law, not the law of one country, but the general notion of the law itself. We find numerous laws and the constitutions creating positive and negative rights, putting liabilities and imposing duties. There is also much talk about different species of right, like the right to life and personal liberty, the right of the consumers, women's right, right of the workmen and artisans, right of children, right to education, right of the backward classes of the citizens, right to information of the citizens, right of the tillers of the soil, so on and so forth. But it is at the root of the problem to ascertain the meaning and nature of right. It is just like giving a picture of a flower. So there are different species of flowers like the rose, freesia, daisy, sunflower, etc. They are all the species of flowers. But that is not the answer to the question. Give a picture of flower. Meaning thereby that what are the qualities, components and the nature that are required in giving a picture of flower, of which rose is only a species. Likewise, the question is, what are the requirements to define what a right is, of which right to life is only an example. The Constitution of India 1950 enacted at Article 13 that laws inconsistent with or in derogation of the fundamental rights are void. Law is defined to include any ordinance, order, bylaw, rules, regulation, notification, custom or uses. Any such law, if it is inconsistent with any of the fundamental rights, is void. The Constitution does not define what a right is, but it merely provided that a law that is passed in derogation of any of the fundamental rights shall be void. The juristic views regarding origin of right. Let us discuss. Individuals are the social units and pre-existed both laws and society. The oldest known acts of human beings are observance of duties, because there was no necessity of conferment of some rights. Referring to the views of jurists and philosophers, we find the absence of any conferment of right. Say for an instance, the view of Karl Marx and Friedrich Engels indicated that primitive tribal society was a state of perfect equality. The society contained no antithesis within itself as long as there was equal distribution of commodities. There was no necessity of passing laws to regulate the lives of the people, as the people lived under a system and a principle of from each according to his ability to each according to his needs. But due to selfishness or greed, distribution become unequal and the society is split into two classes as capital and labor. Gradually, the primitive tribal society is taken over by a state that came into existence as soon as there was unequal distribution of commodities and class distribution developed. Law came into existence to keep the mass in subjugation and to protect selfish interests in protection. In the proletarian dictatorship, law will still be continued to be used as the instrument by which working class people majority can crush and eliminate the capitalist minority. Therefore, the question of creation of the right came into being at a certain time of a community when the necessity to regulate the lives of the people became indispensable due to necessity. The importance of ascertaining the meaning of right is felt in defining a person in the legal theory. Say a person is defined to be anybody capable of rights and duties. Nobody not so capable is a person, even though a human being. Under Roman law, slaves are not treated as a person solely on the consideration that they do not own any right to exercise and have only duties. In this regard, Leon Dewitt stated that what are commonly called rights are only incidental to the relation with other people which arise in the course of performing one's social duty. I having asserted that there are numerous conflicting interests which exist in the life of the community itself, and the state only chooses out of them such of the interests as it will protect by means of legislation. Justice Holmes defines right to be a permission to exercise natural powers and upon certain conditions to obtain protection, restitution or compensation by aid of public force. From the above views, it may be deduced that enforceability by legal process is said to be a necessary condition of right. Rights are certain advantages which are enforceable in a forum in case such right is infringed by another's action. This is also expressed in the maxim ubi jus, ibi remedium, that is, there is no right without a remedy. That was well illustrated in a very old and celebrated case entitled SB versus White, in which Holt Chief Justice held that every legal injury imports a damage even though it does not cost him a farthing. A right is meaningless without a remedy to maintain it. Although enforceability by legal process is said to be a necessary condition of right, yet there are some qualifications to it, as law always does not enforce the invaded right in every case. For example, to cite, in numerous cases of causing of death, there may occur violation of right of life guaranteed by the Constitution. The court cannot enforce the right by giving life to the victims. In such cases, awarding compensation will be an alternative remedy, but not to enforce the right to life. Some illustrative cases I may cite here. In Sebastian Hongre versus Union of India, reported in AIR 1984, Supreme Court 1026. In that case, the army raided in the locality of Ukhrul district of Manipur, and all the male persons of the locality were made to fall in the ground out of the gathering. 2 persons were singled out and were taken to Phugrai camp, and thereafter they have not returned home. A writ petition of habeas corpus was filed before the Supreme Court on their behalf for deprivation of their right to life, which is not in accordance to the procedure established by law. The respondent Union of India could not produce them by saying that they were released after doing some interrogation. The Supreme Court held that it was a case of causing unnatural death and deprivation of the right to life, and as the court cannot give their life, compensation was awarded of rupees 1 lakh each to their wives as an alternative remedy for violation of right. It has become the recognized principle in both civil and criminal jurisprudence to make answerable any person or authority who infringes the right of other individual. A visible phenomena is numerous cases on the part of the government to invade the guaranteed right of the citizens in the guise of maintaining law and order or prevention of crime, etc. Article 9, Clause 5 of the International Covenant on Civil and Political Rights 1966 laid down that anyone who has been the victim of unlawful arrest or detention shall have an enforceable right of compensation. For example, under certain systems like India, guaranteed rights may still remain intact, but its enforcement part is suspended during a proclamation of emergency. The freedoms guaranteed to the citizens, known as 6 freedoms, are automatically suspended. Further, the President may by order suspend the right to move any court for enforcement of such of the rights conferred as the fundamental rights. A decided case will illustrate the position. The case is celebrated one known as ADM Jabalpur versus S. Shukla, reported in AIR 1976, Supreme Court 1207. The Supreme Court held that any claim to writ of habeas corpus to challenge detention on any ground amounts to enforcement of right of personal liberty under the Constitution, the enforcement of which has been suspended by the Presidential Order of 1975. It has been emphasized that the suspension of the right to life and personal liberty did not affect the general rule that executive could not detain a person otherwise than under a law. But nevertheless, it is maintained that the presidential order barred the right to move the court for enforcement of the right to life, so long as the ban is not lifted. For instance, there are certain imperfect rights like a debt which is time-barred. Such rights are recognized only partially and cannot be realized through the machinery of the courts. In India, the example of Section 3 of the Limitation Act 1963 may be cited. The section mandates that every suit instituted, appeal preferred, and application made after the prescribed period shall be dismissed. A time-barred debt with reference to the law of limitation is that limitation bars the remedy but does not destroy the right. Since the right exists, if the debtor pays the debt to the creditor, which has already become time-barred, the creditor gets a good title to retain the money, and the debtor cannot claim back the amount which he paid on the ground that the debt is time-barred. Certain rights are such that they do exist, but the courts of justice do not have adequate means to enforce them. For example, the rights that are declared in international law, which is not yet incorporated into the municipal law of a country. To cite an example is the right to basic needs is one of the declared rights of the consumers, and that is declared by the International Organization of Consumer Union. Even if the right has been declared for the consumers in general, a consumer will find difficulty in enforcement of such a right easily in case of invasion, as the courts of justice would require incorporation of such a right in a law made by the legislature of the land, defining the meaning, extent, scope, and limitation of such right. Only then a court of justice would have adequate machinery to enforce its decision to enforce the right. In appreciating the meaning of nature of right, the view of the jurist like Eyring may be quoted. He asserted that there are numerous conflicting interests which exist in the life of the community itself, and the state only chooses out of them such of the interests as it will protect by means of legislation. During the time of laissez-faire era, laws were concerned only with limited areas of human life like crime and police, defense, land revenue, and administration of justice. But gradually, the society moves from individualism towards collectivism, and also adoption of welfare state policy. Every footstep of the human beings became regulated by law, and the rights and interests to be protected became multifarious, covering numerous areas of human life like right of HIV/AIDS persons, indigenous people's rights, humanitarian laws, right of the child in the armed conflict, right of the people in the disturbed areas, right to life of the child in womb, right of women against domestic violence, right to medical termination of pregnancy, right to education, right of consumer protection, right to information, so on and so forth. So appreciation of the meaning and nature of the right becomes all the more relevant and important than ever before, as the inquiry is not the extent and limitation of right in a country, but the general notion of the term right, which is explained as an interest, respect for which is a duty, and disregard of which is a wrong. Thank you very much.